Good afternoon, Your Honor. Thank you very much. As may it please the court, as amicus, we're here to share some insight in terms of the outcome of this case and the ramifications this case may have on the insurance industry. And although we don't make up a great deal of sympathy for most people, the insurance industry, it also affects all of our insureds, which in this case are physicians or any professionals that will see their rates go up or have availability a threat to them. So, you know, I'd like to rely upon our briefs and my certification, but I want to expand on it briefly. Our job as an insurance industry is to create some sort of certainty when it comes to what we're going to charge our professionals, or in this case it's doctors, in a field of uncertainty where we don't know what that exposure is going to be. And this case strikes at the heart of that uncertainty. We set rates based upon what we think we can predict and what we think that outcome would be. If plaintiff attorneys are allowed to simply fall asleep at the wheel regarding doing their obligation of pursuing a case and being able to refile these cases continuously with minors, we will have uncertainty with how much we can charge. In particular, physicians in this specialty are obese. Yes, Your Honor.
If the adults had filed their claim, with or without an let's say without an affidavit of merit, and they get dismissed, and 5 years, 10 years, 13 years later, the guardian files on behalf of the minor, you'd be in the same position.
Yes, Your Honor. We would not. Well, we wouldn't be in the same position in the sense that in the first 120 days of our suits, it's estimated, and it's not in our certification in complete detail, but we spend about 10 to 20% of our costs in that first 4 months. We send out our files to experts.
That's not what I'm asking. I'm just saying, I understand what you're saying. The minor is going to hang out there till they turn 18. Aren't you in the same position you're complaining about and subject to a valid malpractice suit if the adults file their claims day one and fail to file an affidavit of merit? You know there's a minor out there, because that's what the basis of the malpractice really is, the injury to the minor. They get dismissed. 10, 12 years later, the guardian files on the minor's behalf. Aren't you in the same spot?
Well, in terms of a total exposure, yes, we're in the same spot. In terms of our expenses related to that exposure, no, we're not. Because
so if costs are assessed, are you in the same spot?
No, because if they're able to refile, I mean, you're comparing this if they can refile all the time and get dismissals because they're minors.
No, I'm not suggesting that would be an appropriate rule. I'm just asking if you're in the same spot under my circumstances.
Under your circumstance, are we still exposed to the same liability?
Yeah.
Yes, the answer is yes, but not expenses and not availability, because we have reinsurers that go based and reinsure our policies. So depending on how large you are, we purchase treaties on our behalf to insure ourselves, and they deal with claim years of when they're actually reported. So anytime you have this uncertainty of knowing when an exposure is actually at risk for us, we have uncertainty with our reinsurers as well.
But don't you have that exposure the minute he files his complaint?
We do have the exposure. The problem is not the exposure. The problem is how we actually build this into our costs to physicians. So in other words, at the end of if we have a claim that's brought up against a physician, let's say in November of a certain year, and it's reported, and we don't know whether or not it can be refiled, we have to actually set up a reserve. We set up a reserve. We might have to trigger our reinsurers to tell those reinsurers, this is what we're going to pay in premium for that reserve of that loss.
And your reinsurance, the reinsurance that is available to you may change based upon when that claim is ultimately brought.
Correct. As well as the fact that the physicians themselves, believe it or not, the largest insurer in the state of New Jersey for medical malpractice determines rates based on what they reserve for a physician in terms of their defense or their indemnity. So subjectively, an insurance company, we're not like car insurance with drivers. We have very few things to predict what our losses and our expenses are going to be. And one of those things are what we call loss runs, which is what we put up for reserves to pay for expenses in terms of a case, as well as the merits behind that case.
So if I have my understanding correctly, that if for example, this case were put on hold through a voluntary dismissal and then potentially could be refiled years from now, the reserve would be put in place for the physicians involved and their rates could be affected.
Right.
As a friend of the court and a representative of industry, do you have any concerns about automatic notice going out from the court, general notice to all parties in these sorts of cases?
I don't have any concerns with that. I think that's a great idea. One of the things I did want to clarify, though, is I believe the Ferrer court said 90 days on the presumption that a plaintiff attorney would actually comply with the 60 days. So if they go without 60 days without an affidavit of merit, they're supposed to file a motion to extend that 60 days. So I believe this court said, in order to make sure that we perfect the correct affidavit of merit, we will have a Ferrero conference in 90 days, which was the assumption that a plaintiff attorney would do their job. And that's what we don't have here. The only extraordinary circumstance here is that we have an attorney that believes that they can actually be here today to argue this case.
But at the conference, if there was no affidavit, the judge was supposed to remind the attorney to file the affidavit within the remaining time. And if there was a deficiency, the defense attorney was obliged to tell the plaintiff how it was deficient, correct?
I was under the impression only in that second part, that the Ferrero conference would only examine the deficiency of the affidavit of merit and whether or not it was the right
Covers
specialty.
both.
Okay.
Anything you'd like to add?
No, thank you very much.
Thank you. Thank you to all counsel. We'll take the matter under advisement. Counsel are here for, or some, for Akeem Boone.